Good afternoon, ladies and gentlemen, and thank you very much for joining us today at the European House, despite the very nice weather outside, but I mean, you can still enjoy a little bit from the window. And together with my colleague of the delegation, we are honored to welcome you to this workshop on the recent development in the European Union and in Japan on intellectual property and on privacy law. I trust and I'm confident that the discussion that you will have this afternoon will bring useful and insight on these very important issues to specialists, analysts, and practitioners. But before going into the substance of today's workshop, allow me to spend some words on the importance of the current moment for the relation between EU and Japan. As you may know, back in July, EU and Japan signed the Economic Partnership Agreement and the Strategic Partnership Agreement. And those two agreements together will really bring the relation between EU and Japan to a new dimension, new and reinforced dimension. And the conclusion of the negotiation for a mutual arrangement for the protection of personal data, the adequacy findings, is yet another important element of this new relation. And I'm particularly grateful to the Center for taking this initiative and for expanding the agenda of today's seminar from intellectual property matters only to include also development in the privacy field, precisely the GDPR, and for the bilateral, the adequacy findings I was just referring to. And I think it's really important to stress this element today, and because we do consider that thanks broadly to comparable solution granted to the protection of personal data in our respective legal systems, the European Union and Japan have really managed to create the conditions for an internal market for data exchanges, which I would say eliminate the need for further certification and for the payment of any fees, while ensuring a high level of data protection. And I think it's important to underline these two complementary dimensions, the business perspective and the consumer perspective. Business will have an easy access to our respective markets and will also get a competitive advantage compared to business operators in other parts of the world. So this agreement, together with the Economic Partnership Agreement, will create the biggest area of free and safe data flows. And once again, I insist on free and safe. Those are also two important dimensions of this discussion. And at the same time, by doing so, we will also send a message to the outside world that openness to trade and strong protection can and should be going together. So we definitely have now a very comprehensive framework in place for this new relation between EU and Japan. Getting a little bit more into the subject matter of today's seminar, the GDPR. I would like to say a few words on the regulation now that it has been in place for 6 months. Of course, 6 months is a very short period of time to make an assessment, so the objective is not to make an assessment of the regulation after 6 months, but rather to have a preliminary view on what we have learned from these first six months. And again, I would like to address both the perspective of companies and the perspective of consumers. From companies' perspectives, think we can say that the compliance with these new rules have given them a good opportunity to put their data house in order. So definitely, with the entry into force of the GDPR regulation, business took a closer look at the data they were collecting, asking some very fundamental questions. What are these data for? How do we process these data? And how do we keep them? How do we share them? And as a result of these questions, business have very often reduced their exposure to unnecessary risk and learn how to build trusting relationships with their customers and partners. Always, again, this dimension, business to consumers. And these new rules have also triggered new markets for innovative privacy solutions, such as the privacy by design. From the citizen perspective, they have also gained benefits from this new regulation. I would say more control over their data, but also an increased awareness on safeguards and rights, and also learn that privacy NGOs can represent them in any dispute in these subject matters. So as I said, this is only a very preliminary assessment 6 months after the entry into force of the regulation. But next June, 1 year after the entry into force of the GDPR, the European Commission will take proper stock of the situation. And this will be very good an opportunity to check what has worked and whether there are some issues that can be further addressed. And I would say that this moment in time will be yet another area of cooperation with Japan. And we are, as the European Union, we are really looking forward to the input that we can get from our Japanese stakeholders. And today's seminars will also discuss the unitary patent, an innovation that will bring and provide uniform and protection in all participating member states, and will definitely simplify the protection of intellectual property rights through the single ownership, the single object of propriety, single renewal fee, and single responsible codes, the unified patent code. And I think that the state of play of the long ratification process of the unified patent court agreement is precisely one of the issues to be discussed. And I'm sure that all observers are asking whether the last ratification required that by Germany will eventually be allowed by the Karlsruhe Constitutional Court. So I think you have in front of you a very dense agenda, and as I said in the beginning, I'm sure that given the level of expertise in this room, I'm sure that the discussion will provide very useful and inspiring insights into this debate. And for that, I would like to express my gratitude to the Center for organizing this workshop with this agenda, and I would like to wish you all an extremely fruitful and productive discussion. Thank you very much.